Ladies and gentlemen, the guest has arrived. I request everybody to rise up. Everybody, please put your hands together for the honored dignitaries. Everybody, please be seated. Everybody, please put your hands together to the honored dignitaries on the dais. The future depends on what we do in the present. Mahatma Gandhi. A very pleasant good morning to one and all present here. Honorable dignitaries on and off the dais, distinguished guests, respectful faculty members, dear delegates and students. It is with immense pride and privilege that I welcome you all to the second edition of National Conference on Shaping the Future of Legal Education, Innovation, Practice and Reforms. Organized by the College Union 2025-26, the GLCE, Law Journal and the Bhagat Singh Study Circle of Government Law College, Ernakulam. Now, may I request everyone present here to rise up and observe a moment of silent prayer. Thank you. Please be seated. Over the next 2 days, this conference seeks to create a platform for meaningful academic engagement and critical dialogue on the evolving landscape of legal education in an era increasingly shaped by artificial intelligence, technological advancement, and institutional reform. Bringing together eminent personalities from judiciary, academia, and legal profession, this gathering stands as a reflection of our collective commitment to reimagining legal education for the future. Today, as we assemble here, not merely as participants, but as contributors to an important conversation, we reaffirm the enduring role of legal education in shaping a more informed, equitable, and progressive society. Once again, I extend a warm and respectful welcome to everyone present here for this significant academic endeavor. To formally welcome this gathering, I would like to invite a person known for his humility, dedication, and unwavering presence within the student community. He has consistently worked with both vision and commitment, remaining not merely a representative, but truly one among us. May I now respectfully invite Mr. Nandan R., the chairperson of College Union, to deliver the welcome address. Mr. Nandan R., the dais is yours.
Honorable Justice Jsti Chalameswar sir, Honorable Justice K. Chandru sir, Advocate Manoj Kumar sir, our respected principal, Dr. Bindumal ma'am, Premsi ma'am, Dinesh Shenoy sir, Girishankar sir, distinguished academicians, participants, paper presenters, teachers, non-teaching staffs, dear volunteers, and all gathered today, a warm welcome to one and all. It is with immense pleasure and great pride that I welcome you to the second edition of National Conference, Shaping the Future of Legal Education, Innovation, Practice and Reforms. Following the remarkable success of National Conference 2024 on Constitution in a Changing India, we are delighted at once again bringing together eminent juries, legal practitioners, academicians from all across the country to deliberate an issue that lies in very foundation of our profession, the future of legal education. This conference is particularly special because it is a completely student-led initiative organized by the College Union in association with the Law Journal Club and the Bhagat Singh Study Circle. It stands as a testament to the belief that students are not merely the recipients of legal education but active stakeholders of shaping its future. Today, legal education stands as a critical juncture. While our institutions have undoubtedly succeeded in imparting doctrinal knowledge and theoretical understanding, there remains a significant gap between classroom learning and practical realities of legal profession. The demands placed upon young lawyers today are rapidly evolving, requiring them not only to understand the law, but also to apply it effectively, ethically, and innovatively. There is an urgent need for curriculum modernization that keeps pace with technological advancements, emerging fields of law, and changing needs of society. Legal education must move beyond conventional teaching methods and embrace practical-oriented learning, clinical education, and experiential training internships. At the same time, we must not lose sight of the social purpose of legal education. Law does not operate in vacuum. It is deeply intertwined with society and its aspirations. As future legal professionals, we must cultivate not only competence and expertise, but also empathy, social responsibility, and a commitment to justice. Legal education must therefore nurture lawyers who are not only skilled professionals, but also conscious agents of social change. In this context, innovation and reforms are no longer matters of choice, they are necessities. Whether though the integration of technology, interdisciplinary learning, experiential pedagogy, or institutional reforms, legal education must continuously evolve to meet the challenges and opportunities of the 21st century. This conference seeks to provide a platform for reflection, meaningful dialogue, and the exchange of ideas on these pressing issues. We hope that the discussions, presentations, and deliberations over the course of the conference will contribute to the larger project of reimagining the strengthening legal education in India. Before I proceed further, it's my privilege to extend a special welcome to our esteemed guest. So we are deeply honored by the presence of Honorable Justice Mr. Jst. Chalameswar, former Justice of Supreme Court of India, whose distinguished judicial career and unwavering commitment to constitutional values continue to inspire generations of legal minds. Welcome, sir. We are equally privileged to have with us Honorable Justice K. Chandru, sir, former Judge of Madras High Court, whose contributions to social justice and people-centric jurisprudence have left an indelible remark on the legal landscape of our country. Welcome, sir. I also extend my heartfelt welcome to Advocate Manoj Kumar, sir, who is the Vice Chairman of Executive Committee, Bar Council of India, whose presence and adds immense value to its academic gathering. Welcome, sir. A special note of gratitude to a respected principal, Dr. Bindumal ma'am, whose constant support and encouragement have been instrumental in making this conference a reality. Welcome, ma'am. Now we welcome Dr. Premsi ma'am, Associate Professor of Government Law College, Ernakulam, for making her presence in the conference. Thank you, ma'am. I also welcome Sri Dinesh Shenoy, sir, Executive Member, PTA, Government Law College, Ernakulam. Welcome, sir. Now we welcome Girishankar Sir, Principal of St. Dominic's College of Law, Kanjirapalli, and the former faculty of Government Law College, Ernakulam, whose guidance and mentorship have always inspired us as students. Welcome, sir. I also extend a sincere welcome to all the paper presenters, delegates, participants, faculty members, non-teaching staffs, and dear volunteers. Your presence and contributions are what make this conference a truly vibrant and meaningful academic platform. Welcome you all. As we conclude, let us remember that war destroys what humanity works so hard to build. Peace is not a sign of weakness, but the strength and wisdom. Let us raise our voice for peace and say stop war, save lives, and build a better future for all. Thank you.
Thank you, Mr. Nandanar, for your warm and thoughtful welcome. And we welcome you to this conference. Now, we move to the presidential address. An eminent academician, a distinguished presence in the field of legal education. She continues to inspire this institution through her leadership, scholarship, commitment in academic excellence. May I now respectfully invite Dr. Bindumal VC, Principal, Government Law College, Ernakulam, to deliver the presidential address. Ma'am, please.
Honorable Mr. Jst.JASTI CHELAMESWAR, Honorable Mr. Jst.K.CHANDRU, Advocate Manoj Kumar, Dr. Girishankar SS, Mr. Dinesh Shenai, Dr. Premsi, Nandan, Nandana, other dignitaries on and off the dais, ladies and gentlemen. It gives me immense pleasure and honor to be a part of this prestigious national conference. I extend my sincere appreciation to the organizers for bringing together distinguished academicians, judges, lawyers, and students to deliberate on a topic that is both timely and significant, shaping the future of legal education through innovation and practical engagement. Legal education occupies a unique and powerful position in society. It is not merely a process of teaching statutes, precedents. Rather, it is a means of shaping minds, promoting justice, strengthening democratic values, and preparing socially responsible legal professionals. We are social engineers. The quality of legal education that directly influence the quality of our legal system and ultimately access to justice itself. Today, we are witnessing rapid technological advancements, changing social realities, and emerging legal challenges. In this dynamic environment, traditional methods of legal education alone may not be sufficient. We need an educational system that is interdisciplinary, practical, research-oriented, and skill-based. Effective legal education, we can't achieve it without strengthening both teachers and students. Teachers, their role is changed. They are facilitators, they are mentors, they are innovators and guides who inspire critical thinking and ethical responsibility. Therefore, continuous faculty development, exposure to the digital technologies, digital learning tools, research opportunities, that is essential. Likewise, students must be equipped not only with the legal knowledge, but also with advocacy skills research ability, aptitude, drafting skills, negotiations, legal writing, and also professional ethics. Here, the regulatory authority and the policy making bodies, they have a responsibility in this process. Their institutions this entrusted with this regulatory nature, that is legal education, they must prioritize quality, innovation, accessibility, and accountability. Regulation should not merely function as regulatory bodies should not merely function as supervisory mechanisms, but should actively encourage excellence, academic freedom, skill development, and socially relevant legal education. As we discuss the future of legal education, we must remember that reform is not the responsibility of one stakeholder alone. It requires a collective commitment. Universities, teachers, regulatory authorities, legal professionals, and society as a whole. I am confident that conferences such as this serve as a valuable platform for meaningful dialogue, constructive reform. I once again express my happiness and gratitude for being part of this gathering and look forward to the insightful discussions and ideas that will emerge from this conference. Thank you.
Thank you, ma'am, for your inspiring and insightful address. We now arrive at the most significant moment of this inaugural session. It is a profound honor to welcome a jurist whose voice has consistently stood for constitutional morality, judicial transparency, and institutional accountability. Jst.JASTI CHELAMESWAR, former judge of Supreme Court of India, is widely respected for his fearless commitment to democratic values, judicial transparency, and independence of the judiciary. A jurist who has always stood firmly by what he believed and spoke. From serving as the Chief Justice of High Court of Guwahati and High Court of Kerala to becoming one of the most influential voices in the Supreme Court of India, his judicial journey continues to inspire the legal fraternity across the nation. His courageous dissent in the National Judicial Appointment Commission judgment and his unwavering stand for transparency in judicial administration continues to shape the important conversations within the legal fraternity even today. It is indeed a profound honor for Government Law College, Ernakulam to welcome you, sir, to this conference. With immense respect, may I now invite Honorable Jst.JASTI CHELAMESWAR, former judge of the Supreme Court of India, to deliver the inaugural address. Your Lordship, the dais is yours.
My esteemed brother, Justice Chandru, other dignitaries on the dais, of course, I must sound like a copycat if I use this expression, my fellow law students, because I'm a little hesitant to use this expression, though I'm not a hypocrite. But then I might be dubbed as a copycat. I remember long back when I was a student, addressing one of these gatherings like this, that giant of a lawyer this country produced in the 20th century, late Nani Palkhiwala, used this expression, my fellow law students. The whole Indian press went gaga, oh, what a great man, he said. He was speaking simple truth. Legal education, for that matter any education, is a lifetime process. It can never be complete. If somebody who acquires a degree in law thinks he knows the law, it is not only trouble for him, it is a trouble for the whole society. I, for myself, I can say with, I don't get anything today by boasting or speaking falsehood. I looked at every case I handled, either as a lawyer or as a judge, as an examination. It's a challenge. We have something to learn from every case. That's what I believed. And it helped me in my career. And I would very honestly and sincerely recommend to all of you to keep it in mind. Legal education is never complete. As I told you, for that matter, no education is ever complete. There's always something to learn. Now, what we learn in the law colleges, if we are serious about learning, is only the introduction. The law colleges teach us, or at least expected to teach us, how to approach the subject of law. Afterwards, it's your own exertion. Every time you handle a case, you study the case, the legal niceties of the case, the implications, the jurisprudential background, and the precedents covering that case. It's an eternal study. The topic for today is legal education, innovation, practice and reforms. Innovation, in my view, presupposes you understand perfectly what is the existing system and you believe that it is required to be improved. Therefore, there is a need for innovation. Well, for a good number of people in this profession, innovation need not necessarily be based on a complete understanding of what is the system. Whatever crosses their mind. In fact, in one of the judgments, a legend in his own lifetime, incidentally from this state, late Justice Krishna Iyer, said about judges. Forgive me, at the age of 73, my memory is not perfect, but broadly, it could be a lapse in the narration. He said something like this: a judge cannot rush to conclusions on the basis of the ad hoc dictates of his unguided conscience. It is a great caution which he gave to the members of the judiciary. Unfortunately, in this country what happens is we deify people, we worship great people, but we don't follow what they say. That's what happens. The father of the nation, he didn't preach any great political philosophy like Karl Marx or XYZ. He only said something simple: speak truth. We are finding it very difficult to follow that advice in this country. We hardly come across anybody speaking truth in any walk of life. Anyway, forget it. But when you talk about innovation, please remember Justice Iyer's caution. Innovation need not mean reckless adventures. Innovation after a perfect understanding of the problems facing the situation in a given case or in a given situation, then perhaps there is a scope for innovation. Similarly, in the field of legal education, when we are talking about innovation, there is scope for innovation, in fact. I'll tell you the reason. We take the body of law broadly. In a short 1 hour lecture, I can't go beyond this. We take law into two branches, public law and private law. Public law, once again, dealing with constitutional law, and administrative law is an offshoot of constitutional law. That's at least my understanding. There can be other views. Now, that's one branch of study of law. Study of constitutional law requires a good knowledge of history, the evolution of constitutional law, and the application of constitutional law as embodied in the basic document, constitutional document of this country. I am talking about only the Constitution. Now, for the last 75 years, the lawmakers, it is a shorthand word for politicians, in my view, talk about India being a federal polity. Socially, it's a federal polity, I have no doubt about it. We have people speaking innumerable languages in the country, following innumerable cultural practices, following number of religious practices, and various stuff. But fortunately, so far we have coexisted in this country with all these varying variable factors. But legally, whether this is a federal constitutional structure, I have grave reservations about it, and I believe it is not. Even the Supreme Court never emphatically said it's a constitution, the federal constitution. A little made up expressions like cooperative federalism, quasi-federalism, a little qualification, but never a definite statement is a federal structure. No, maybe it was the requirement of the day when the constitution was prepared. Or maybe it's still, I don't know, these are not matters which can be decided in 5 minutes in a 1 hour speech. These are matters which require a large amount of debate. But now, just to give one example, the whole idea of a federal constitutional structure started sometime in 1930s, when India, as which we know, you and even me for that matter, I was born in 1953 after the formation of the Republic. Maybe I'm much older than you, but then I was also born in free India. Before all of us were born, India as we know it, the geographical territory of India as we know it today, was in two divisions. A major part of it, 2/3 roughly of the major part of the territory, was directly controlled by the British. And remaining 1/3 was under the control of the various principalities, like your immediate example is Travancore, Mysore, and so on and so forth. There are innumerable small principalities which owed allegiance to the British Crown but strictly not part of the British India. Now, it was in that context when the Government of India Act 1935 was in contemplation, the idea of creating a federation commenced. From there it took a lot of, it's a complete study by itself. Those who are interested in constitutional law and constitutional history may pursue it. But finally, when we have the Constitution today, what is federal about it, I don't understand. Elected state governments could be dismissed before they complete their term of 5 years if an individual is satisfied that the government is incapable of running the state in accordance with the Constitution. There is a breakdown of, well, it's an individual opinion. Maybe sometimes the opinion is correctly formed, sometimes it's not formed. But the very provision which enables that kind of an exercise, in my belief, is anything but a federal structure. Now, one more example I'll give you in the context. The transfer of High Court judges. In a federal country, it was a provision copied from the Government of India Act, the provision enabling the transfer of High Court judges. I didn't see any theoretical justification for it. I don't know why it was incorporated, because for those days, well, it was a foreign ruler. He treated judges as civil servants. Now, judges are sought to be transferred, and they are transferred. God alone knows why they are transferred. That's a different story. Somebody was mentioning about whatever I did in the Supreme Court, about collegium and so on and so forth. I said, please explain why are you transferring X judge or Y judge? Nobody gives that explanation. And we still believe we are federal. Forget it. And in the last 75 years, the Indian Constitution, a wonderful document prepared by the founding fathers, textually guaranteeing a lot of fundamental rights to the citizens of this country, and some even to non-citizens, fundamental rights. In practice, how those guarantees work to the protection of a common man, if a proper audit is conducted. Of course, I don't have the statistics ready, but with my life experience, I can say the audit report would be very uncomfortable to read, if not anything, if not more stronger words. All that it requires to deprive the liberty of an individual is that somebody in the government must believe that the activity of this gentleman or this lady, X, is detrimental to the sovereignty of this country. What it means, God alone knows, if a God exists. And I suspect God exists, but anyway, there's a different debate. I don't want to go into it now. And starting from A.K. Gopalan till today, what is that gentleman? Wangchuk, is it? That Ladakh gentleman. How effectively the Constitution and the machinery created by the Constitution protected the liberty. Now, I remember a former law minister of this country, India, well, this was a big problem thereafter, made a statement at some point of time, perhaps with some justification. In whatever language he said it, in substance he said, all these liberties only help smugglers and tax evaders. Factually, these liberties and this process, the system which is designed to protect the liberties, never came to the aid of people like Jayaprakash Narayan, Ram Manohar Lohia, or anybody like this. They never got any habeas corpus relief in any court. Lesser mortals, smugglers and tax evaders, they get it very fast. That's a different matter. Maybe they are also entitled. I am not denying merely because a particular person is an offender, it does not mean he loses. That's what Justice Iyer used to say. Even a convict is entitled for certain liberties, certain rights subject to the overall limitations of law. Anyway, now in the process, where is this public law, the constitutional system progressing, is a matter for each one of us to examine, decide the future, especially you people. We are all on the way out. Maybe a few more years, I don't know, maybe tomorrow, God knows, who knows. We are on the way out. You have a long life. You are going to be tomorrow's lawyers, judges. Maybe some of you will become lawmakers, MLAs. In fact, a young girl who initially, what is that girl's name who first spoke? Huh? Oh, this girl. I see a great potential in this girl to become a leader. The way she delivered. Now, the way she delivered, well, when you are luck in politics, I don't say luck, do it. But then, I tell you, though all of us have not a very wonderful opinion about politics, but in theory, if practiced with sincerity, that is a great occupation or great calling. basically they are supposed to be working for the welfare of the people. Now, how many of them are really doing it is a different story. That's where all of us have problems with them. But otherwise, as a occupation or as a calling, pursuing politics is, I don't believe it's bad. Only thing is, do a little better. That's all I request from all of them. We can't avoid politics. No, but where are these political forces leading us in the next, in your lifetimes? It will be in your hands. Your hands may not only those sitting in this hall, but your generation, those who are in law colleges, those who are in various other colleges. That of late I've been watching on the YouTube some gentleman who is not even a lawyer is taking on the Indian judiciary left, right and center. Some gentleman from UPF, I forgot his name. Not necessarily that only lawyers should speak about it, others. They are all citizens, they are bound by the law, they enjoy the privileges of law, they suffer the inequalities created by the law, everything they are entitled to comment, they are commenting. But as students, you must study what is happening. That is one part of the public law, study of public law. Their innovation also is possible, but it's at a much higher and larger plane. Individuals can't innovate in public law in the sense, okay, you become a Supreme Court judge, afterwards whatever you say is the law of the country for that day. Unfortunately, in this country, the Supreme Court, which sits in a division benches, the law declared today will not be the law tomorrow. You remember about a year back, a division bench of the Supreme Court passed a judgment in the controversy arising out of Tamil Nadu governor's action in not clearing the bills for years together. And I think within a matter of 2 or 3 months, the judgment was tweaked. So there is no guarantee in a highest court sitting in division benches. There is no stability in law. It keeps fluctuating from time to time. No, change in law perhaps is desirable. If I may not be understood as trying to say something about my own this thing, for about 60 years in this country, the highest court believed, laid down repeatedly, that right to vote, all rights relating to elections, because there are innumerable rights pertaining to election, right to vote, right to contest, right to be an election agent, so on and so, right to challenge an election petitions, all. The Supreme Court repeatedly held they are statutory. Then for the first time, sometime in 2008 or 9, PUCL case, one learned judge, incidentally, with pride I can say, he comes from the same High Court from which I came, Justice Venkatram Reddy, wrote one sentence that it is a constitutional right. He didn't elaborate it. It fell to my lot to elaborate it in 2 judgments, initially in a dissenting judgment in Pranab Mukherjee's election case. Second time a majority judgment, luckily my colleague on the bench agreed with me on the view. In though Rajbala is one of my bitterly criticized judgments for other reasons. But we held that it's a constitutional right, it became a majority judgment. And fortunately, last week though, there are a lot of comments about that judgment. The Constitution bench of the Supreme Court in the context of SIR approved Rajbala. Now at least a Constitution bench says it's a constitutional right. The era of Ponnuswamy is gone once for all finally. I don't know. Maybe another 7-judge bench may tomorrow say something else, whether I don't know. But then this is the evolution that goes on. As I said in my NJSC dissenting judgment, quoting from a famous American scholar, in the context of American Supreme Court, he said it, but it's true of any court, any democratic constitutional court. In the context of American Supreme Court, he said, I do not believe the judgments of the Supreme Court, he meant the American Supreme Court there, are synonymous with constitutional truth. A court which held slaves to be non-persons. If you have completed your constitutional law paper and had a peep into American law, Dred Scott's case, the American Supreme Court denied the leave because it was a black. Only whites are entitled for this. So, a court which held slaves are non-persons. Separate is equal. Till 1952 or 53, Brown was the Board of Education. Colored children had separate schools and white children had separate schools and so on and so forth. It was justified by the Supreme Court until finally reversed in Brown versus. So in that context, Lawrence Tribe is become old, teaching in Harvard. He said, I do not believe the judgments of the Supreme Court with synonymous with constitutional truth. But what he says is, such passing finality as the judgments of the Supreme Court have is essentially a compromise between order and chaos. You have to accept the finality somewhere until refined or rectified. Otherwise, you'll have to settle issues on the street with sticks, which perhaps is not a very civilized way of dealing. In the process, maybe a generation or a couple of them may suffer injustice, that's a thing, but then it's still a refined process, a relatively refined process. Ideal processes are different matter. Now, it's for your people, your generation, to decide how to innovate in the field of constitutional law. As I told you, you are tomorrow's lawyers, judges, perhaps lawmakers. Some of you may become administrators, I don't know, IAS officers, police officers. You'll have to administer the law. It's for you before you innovate. But please try to have a clear understanding of what is going on. Second, in the field of private law, history, technology play a great role in the formation or innovation or reform of law. Now, I'll just give a very crude example. The law of contracts. Earlier days, if somebody drew a check and the check bounced, the only remedy available was to go and sue the drawer of the check for the amount, and then you know what all happens thereafter. At least you should try to know as lawyers. Some of you, if you're in the final years, by now you would have had an understanding what happens thereafter. Then, after long experience, the Parliament came out with an amendment to the Negotiable Instruments Act, saying that it is taking too long a time. Somebody signs a check and then it bounces. And the drawee of the check, the person who is receiving the check, will have to run around the court for 1, 2, 3, 4 courts, 10 years, 20 years, whatever it is. The better thing is to make it an offense. If a check bounces, it becomes a prosecutable offense. The man will have to go to jail. And this amendment came sometime in 1980s. Once again, the same story, matters are going on. I'll tell you a hilarious example. Some case, somebody drew a check, it bounced, man was prosecuted, convicted, then appellate court did something, I don't remember exactly. Finally, it all landed up in the Supreme Court before a bench of which I was a member. As a judge, I didn't have a very good reputation in these matters. They knew that I'm a troublesome judge. I was not very kind to this kind of a thing. The lawyer made a grand, my lord, we have spent enough time in this process. My client is willing to pay the money. Your lordship may consider setting aside the conviction and sentence. Will pay the money. Of course, there was another judge in the Supreme Court with me. I asked whether what is. He said, all right, if he is paying the money, why should? I said, wonderful. You pay the money. We'll set aside the conviction, but one condition I'll impose. You have wasted so much of judicial time. A time could have been usefully employed in some other genuine litigation. Compensate the system for this damage you have caused the system. Apart from paying whatever is due under the check, not only the principal amount and interest, pays something to the society, pays some amount to the legal service authority so that that money can be used for some case of some poor litigant who can't afford this thing. You know, see, the parliament innovated, but in practice, this is what is happening. How to handle one standard accusation in this country, all these, not only perhaps in this country, every country it is there, but the time scales vary. Laws delays. Everybody talks about laws delays, both in civil matters, criminal matters. Just about a year back, I was here in Wayanadu Literary Festival. In one of the sessions, they organized a conversation between me and a sitting member of the parliament, Mr. Britas, who is a member of the Rajya Sabha from your state. And naturally, anybody would like to have fun when a judge is available, particularly a retired judge with no power to punish for contempt. So, of course, he's a nice man, otherwise I knew him. But then he got an opportunity. He said, but Judge, what do you talk about these inordinate delays and laws, blah, blah. All said and done, I may not be a great lawyer, I may not be a great judge, but I know this kind of situations, how to handle them. I told him, it's all available on YouTube. I told Mr. Britas, I agree with you, there are a lot of delays. But can I suggest something? He said, yes, Judge. To my knowledge, quite a good number of your colleagues in the parliament and members of the legislative assemblies of various states facing criminal cases. Quite a good number. No, some of them may be genuine cases, some of them may be utterly false cases. I am not passing any judgment about it. If you are talking about laws delays, why don't you first make a law, let the reform start at home? Why don't you initiate a bill in the parliament that the cases of sitting members, persons holding constitutional offices must be tried expeditiously by an exclusive court or exclusive bench or whatever it is. Everybody clapped. And Mr. Bitra said, Judge, you are bringing me. I said, when you ask for trouble, what do I do about it? The point is, it's all very nice to talk about these reforms. Question is how well we are able to implement them. Just one more example in the context I tell you. The last judgment I wrote, not because I wrote it, because it contains the information. A particular case from Gujarat, criminal case. 3 people died. There's some local faction, nothing to do with communal violence or anything. Simple local faction fight. 3 people died. 17 people were accused. Other side also some people were injured. A counter case was registered, but there was nothing on the record to indicate what happened to the counter case. And in the process, of the 17 accused, 2 people were convicted for 302. Old 302, now the numbers changed. Others received conviction for lesser offences. There was a... please read the judgment. It has all the shortcomings of Indian legal system in the administration of criminal law. All the shortcomings. An omnibus charge running to 2 lines. There are all 17 of you charged with 143, 144, 149, blah, blah, blah. Charge was framed. Whereas the first principle of criminal law is charge must be specific. In spite of it, an omnibus charge was framed against all the 17 people. Wonderful. Having framed a charge under 143, I don't know what assistance the public prosecutor was giving and what the trial judge was doing. Charges were not framed properly. Forget it. Coming to the decision-making process, the trial court did not record a conclusion whether there was an unlawful assembly or not. 144. If there is a finding that there is an unlawful assembly, 2 people are found guilty of 302. Constructively, others would be liable subject to the other conditions for the same punishment. There is no finding on that. And most interesting part of the case is, on the face of 3 dead bodies, the postmortem reports are available only with 2 dead bodies. With reference to the 3rd dead body, the postmortem report was not available. God alone knows what is the cause of death. Fair. There is another problem. And the icing on the cake is 2 people were found guilty of 302 of the 17. The judgment is silent of causing whose death. Ultimately, when you find somebody guilty of 302, a specific finding says you caused the death of X. Therefore, if it is not possible to assume in criminal law, assume for the sake of logic that both the fellows are found guilty of killing all the 3 people, we will presume it favorably or logically. Presumption itself is illogical. Even as presume it, then there must be conviction on 3 counts. Sentences may run concurrently. A single you are found guilty of 302, life. And by the time the matter came to be heard by the Supreme Court, these 2 people served 14 years and finally released. This is how the system functions. And at every step, that's why I said, not because I wrote the judgment, I quoted this case because every shortcoming in the administrative criminal law, you can see it in the judgment. And this whole system, the investigation, the trial, the public prosecutor, what kind of assistance he was giving, the judges, what kind of a decision-making process is this? At least the court should have asked, where is the 3rd postmortem report? Nobody asked the question. Anyway, see, talking about, this is the reality. You can talk about innovation later. First understand what exactly is wrong with the system, how to rectify the existing system. Innovation we can do later. Please think of innovation, I am not stopping you. But before you attempt it, you be very clear about what is going on, what is the system. Coming to the private law arena, take the law of contracts, for example, commercial law. When the British introduced the present Contracts Act, essentially contracts were intrastate contracts within the country. Now from there, the modern technology, transport facilities, migration of people, huge amount of interstate commercial activity has come into existence. And if anybody in the gathering is interested in economics, I was a student of physics, I was not a student of economics. My knowledge of economics is very, very peripheral. But I know with experience, every day when you say everybody talks about growth rate, GDP, this, that and all those things and all this foreign exchange reserves, and then of course the other day the Prime Minister said stop buying gold. Well, these are all economic implications are there in these matters. And then trans-border commerce. All this is became possible because of the modern technology, transport facilities, communication facilities. Earlier, if somebody had to enter into a contract, 2 people, they had to get together, discuss, debate and settle the terms of the contract. Now people need not meet. They may not even know the face of the other side. On telephone, on telex, on email, contracts can be formed. Contracts can be, am I audible? Yeah. No, necessarily with that the law had to undergo certain further changes. All of you know, I am just giving only examples I am giving. See, the Evidence Act is amended, laying down the principles how electronic documents are to be proved, digital signatures are to be made, so on and so forth. This is all part of modernization. The legislature is doing some attempt to modernize the thing. Now, it requires further on the question of the interpretation of these things. Perhaps we need to, out of my experience, I can tell you something. I was one of the members of the bench though the judgment was actually written by my colleague on the bench, Justice Nariman, now a very famous judgment, though nobody obeys it, Shreya Singhal, who struck down Section 66A of the Information Technology Act. Some 12 years after the judgment, in fact, I remember some time back I saw in the newspaper, Delhi High Court came down heavily on somebody saying that the section was still being invoked and crimes were being registered under that section 12 years after the Supreme Court declared. That is another problem of this country. When that matter was being debated before us, Section 66A, who is who of the Indian bar was there, starting from late Mr. Soli Sorabji, downwards in the sense age-wise. Soli Sorabji, Gopal Subramaniam, so on and so forth. Then came at the end, younger generation. So at some stage, Justice Nariman said, whether we have heard enough things, should we hear all these youngsters? I said, brother, please listen to them for two reasons. First of all, I don't want the youngsters to feel that the court doesn't care for them. That's one consideration. Second thing, more important according to me, Soli Sorabji may be a great constitutional lawyer, but you ask him something about computers, his knowledge is very, even for that matter, my knowledge, I can hardly handle. In fact, one of my colleagues in the Supreme Court, in one matter when something like this was going on, he made an open statement in the court. He told the lawyer, Mr. So-and-so, I don't know how to handle a smartphone. What is the point in telling me all this? Tell my brother he knows something about it. He said, because my knowledge is also very limited. I am not claiming any great knowledge of I'm not very tech savvy. But I know to the extent which I need, I now can handle a phone or an iPad or something like that. The point is, some of these youngsters, when I told them, brother, listen to them, some of them may have something more useful to contribute from the point of view of technology, because the whole thing is about technology, that section. And I must tell you, a couple of them were brilliant beyond imagination. I was wondering those days whether I could have advanced an argument like that when I was of that age. That level of brilliance, I saw some of these youngsters, they're brilliant. A hilarious example, when a senior advocate was arguing in this matter, some young girl was sitting in the second row. The advocate was making a submission. The girl was very violently shaking her head in disapproval, obviously, of whatever was being submitted. I noticed it. So I called the girl. Young lady, apparently you have some reservations about what is being submitted. Then naturally she panicked. Suddenly the judge caught her and, no, my lord. I said, don't worry, tell me what is it. Then she looked around for a few seconds and then she made bold. And technically she explained what exactly was wrong with the submission that was being made by the senior advocate. No. See, reason is simple. Familiarity. My maternal grandfather was a lawyer of 1924 vintage. He, incidentally, as an incidental, he contested the second Lok Sabha and lost the election. The family story is, those days elections were not fought with this kind of level of battle, this thing. So my grandfather having continued, actually he lost marginally with 2,000 votes. Lok Sabha losing 2,000 votes is something very serious. But then, on the day of counting, he didn't go to the polling booth, he sat at home. He was a lawyer, sat at home. He wanted to know what was going on. He didn't know how to tune the radio. There was a radio at home. He called my mother's younger sister, who was the youngest of his children, and asked her to tune the radio. He didn't know how to tune the radio. Then for our generation, tuning a radio was known as a matter of course. We didn't have any difficulty from the childhood, we were handling it. When it came to computer, you have some problem with my iPad or my smartphone, the first thing I do is I call my grandchildren. They know how to handle it. But I know, so long as it's functioning, I can work with it. But if there is some problem, I can't handle it. The reason is this: from a very young age, they are exposed to it. It is the exposure which brings knowledge to human beings. They are more comfortable with it. So similarly, when this argument was being made, these youngsters, their understanding of technology, information technology, and thing is far, far superior to any great lawyer of this country. So there is always, with technology, all these things come, and then there is always a need to improve the efficiency of the legal system. Maybe there is scope for innovation. And even the days of computers is history now. Days of artificial intelligence. It's going to, in fact, I don't know, I'll be very happy if any one of you, I don't think I'm trying to be condescending. Is there anybody in the gathering who read a book titled 21 Lessons for the 21st Century by Noah Harari? If there is somebody who has read that book, please raise the hand. I'll be very happy. I'm very unhappy. Nobody read the book. Please read it. You read it, is it? Good. He says, broadly the theme, by 2050, the world would be such a changed place that it will be difficult for us to imagine today how it is going to be. And he says there are two reasons for this huge change: artificial intelligence and progress in biotechnology. These two are going to make such a difference to humanity in the next 25 years. I mean, this book was written 15 years back. From today, we reckon another 25 years. And he gives us a glimpse of what is likely to be. I'll give you one example here relevant for the legal profession. He gives an example. I'm sure some of you must be driving cars, motor cars, if not all of you. Actually, today some young student brought me here. He was driving the vehicle, second year, I believe. Some of you must be driving. When somebody is driving a motor car on a highway at a high speed, it happens anywhere, and in this country it happens more frequently. Suddenly somebody crosses the road, apart from buffaloes and dogs crossing. Human beings cross, and at times it could be a child. The driver has a problem. He's proceeding at such a velocity, the child is crossing the road at maybe 100 meters, 200 meters. He has to take a decision whether to brake the car, to how strongly the brake should be applied. Depending upon the velocity and the distance between the child and the car, if high pressure is applied, there is a possibility of the car turtling. And imagine there are 4 people in the car. Such a decision could jeopardize the lives of all the people in the car. Then the question is invariably, is it to save the life of the child or save 4 lives in the car? The answer to this question depends upon the ethical values of the driver. What he values, a young life which has a great potential, maybe the child would become an Einstein. Or simple mathematical equation, 4 lives against 1 life. The decision depends upon the ethical value system of the driver. Depending upon whatever he believes, a human being takes a decision. And Harari says, by 2030, 35, driverless cars become a norm in the world. Not complete, maybe substantially. US, a lot of driverless cars are coming. We'll also get them slowly. It's all computer driven. In a situation like this, where the example I gave you a minute back, a computer driven car also takes a decision whether to apply the brake or not to apply the brake and with what pressure it should apply. But the decision, eventually it results in an accident, either the death of the child or all the 4 people or 2 people in the car. The decision is taken, and then all this will lead to litigation, motor vehicle accident claims, blah, blah, blah. Now, this decision whether to apply the brake or not is taken by the computer. This question of ethical correctness of the decision depends upon the person who wrote the computer program for that car. Not all the car manufacturers do not engage the same person to write the same computer program. So the programs may vary. It all depends on the ethical values of the person who wrote the computer program for that particular manufacturing company. This leads to complicated lawsuits. You can imagine now what kind of complications in law can arise. This is only a glimpse of what is going to be in the next 25 years. This applies to across the spectrum for law, for various other areas of human life. Now, these are the challenges which you people will have to get ready for if you are serious about this profession. You simply want to just get into the profession, go move a bail application, make some money, put it in the pocket, go home. Wonderful. That's a different story. But if you are serious, now that you are having a conference, obviously the idea is to debate and enrich yourself in knowledge, not financial. There's nothing wrong in making money, but work for it. That's all I am saying. In fact, between 1950 and 1975, study of law was not a very preferred branch of study in Indian society. A personal note, when I decided to join the law college, my father, who was a law graduate, he didn't practice for long, didn't speak to me for 1 full year. He was totally against my joining the law college. Continuing the personal note, when I became the additional advocate general, my mother cried. When I became a High Court judge, my mother cried. She's still there, she's 95. When I became Chief Justice, she cried. When I became a Supreme Court judge, she cried, only for one reason. If only your father lived to see this day. My father died in 1991. It was not a very preferred branch of study. Post 90, there is a huge renewal of interest in the profession. For all the activity in human life, economic reasons are the most prominent reasons which propel our the amount of money in circulation. The fee structure in this profession, there is no structure, of course. Ask, it shall be given. It all depends. If you are in demand, you can quote anything. And for information, some of these very successful lawyers in Delhi earn more than Amitabh Bachchan, Shah Rukh Khan, Rajinikanth, Mammootty, all these people put together. I don't want to name, of course it's a matter of record. I know a particular senior advocate, in one case, just one case, he charged a fee of 182 crores by check declared in income tax. That is the scale of... So naturally with this kind of money available, anyone now, just as this film glamour, at least I know my state, Andhra Pradesh, there used to be a gentleman called N.T. Ramarao who eventually became the chief minister. He was a glamorous man. After he became a success, some 5,000 youngsters went to Madras to become cinema heroes. But nobody became another N.T. Ramarao. That's a different story. It's the glamour and success that attracts people. This is the kind of money which is there in the profession today. Therefore, there is a... When I got into the law college in 73, there were 3 law colleges in combined Andhra Pradesh state, which is divided into 2 today. When I became a judge in 1997, the very first judgment I had to pen, sitting with the then Chief Justice of Andhra Pradesh, incidentally the Chief Justice who recommended my name for elevation, it was a judgment on a letter written by the Bar Council of India saying that there is a mushrooming of law colleges in Hyderabad city, please look into it. We had to direct 17 of, there are some 34, 35 law colleges that day in Hyderabad city alone. We had to direct 17 of them to be closed down. They were running from car garages, all kinds of places without any equipment, without proper teaching staff and something like that. We directed all of them to be shut down. In a couple of years, all of them came back because they said, we have rectified, we have acquired a building, we have acquired a library, so on and so forth. And the point is, these problems apart, there is so much of enthusiasm, interest generated in the study of law. The chief reason is economic reason. There's huge money. Everybody hopes to become a successful lawyer. Please become. Will become a lawyer, make money, I'll be happy. So long as you make it the right way. But why is it that some of them are becoming such successful lawyers that there's huge money minting machines and not others? Please think it over. All these people who make this amount of money, 200 crores, 300 crores an annum, you may say anything about them, various other things, but the baseline is they are very competent lawyers. They are very competent lawyers. They may have other aspects which may not be very wholesome. Let us not go into it. It's not our problem. But they are very competent. Therefore, they become. There may be additional factors which support it. Somebody has a political affiliation to support him. Of course, the standard dig. In fact, when I was in the Supreme Court, a conference like this organized in Delhi. Addressing the students there, number of students from various law colleges all over the country were there, including national law schools. I said, unfortunately, many of the products of these national law schools are not entering the profession but going after the corporate jobs. I do understand the difficulty. There is some stability in this profession. It's a long waiting game. I know it. But then I said, in the interest of the profession, I said, please get into the profession. When the meeting was over, we were having tea. Professor Mitra, who was the Vice Chancellor of National Law School, Jodhpur, I think those days, at that point of time. So he came, he was a very outspoken man. I never met him earlier, but I heard of him. So he came and accosted me. He said, Judge, can I tell you something? I said, yes, Professor. You assure me that you will not hold me for contempt. I said, Professor, I never held anybody for contempt in my... By then I had been a judge for some 14, 15 years in High Court or Supreme Court. I never hauled up I never sent anybody to jail on contempt charges, I said. Then he said, my students will not come into the profession. I said, why, Professor? And you know what he told me? Of course, I have no proof. You must trust me. He said, your profession is a father-in-law's profession. Unless you have a successful father-in-law in the profession, nobody will come up in this profession. He said, that is an accusation. No, it's a partial truth. Sir Aladi's father-in-law was not a lawyer or a judge. My father-in-law was not a lawyer or a judge. My father was a non-practicing lawyer. That's a different matter. You know, but there are additional factors which do help. But only because you are related to some successful lawyer or judge need not necessarily be you are a success. No. If you resort to some malpractice, temporarily you may gain some success. Afterwards it will not be there. Forget about that. But there is a renewed interest in the study of law. By the time you leave the law school, please have a clarity on what is the purpose of all this. Ultimately, all this is meant for people, for maintaining an orderly society. Why an orderly society? Because the powerful man, either physically or financially or politically powerful man, can always take care of himself. It is the weaker person, either financially weak, physically weak, politically weak person who will not be able to defend himself in adversity. The role of law is to help that man. When I say man, unfortunately, girls will forgive me, it's an old habit. Man includes woman, in another penal code. So it is for them we must study and understand and improve the system. I think I have taken enough of your time. I am grateful for your college, your union for inviting me, giving me one more opportunity to visit God's own country, which I had the good fortune of serving for 18 months as its Chief Justice. Thank you all.
Thank you, Your Lordship, for those profound and enlightening words. Your reflections have truly set the tone for the deliberations ahead. We now move to the address by our esteemed Chief Guest, Honorable Justice K. Chandru, former Judge of High Court of Madras. He began his journey as a student activist, fearlessly advocating for the rights of marginalized and oppressed. Carrying those values throughout his legal and judicial career, he went on becoming one of the most respected voices in Indian judiciary. He is known for his simplicity, integrity, and unwavering commitment to social justice. Justice Chandru disposed of an extraordinary 96,000 cases during his tenure on the bench, leaving behind a legacy of accessible and people-oriented justice. His life and legal journey, which inspired the acclaimed film Jai Bhim, as well as his autobiography, Ennada Arasiyal Varum Nanum, I Too Become a Judge, stand as a powerful reminder that law can truly become an instrument of social transformation. It is indeed a great honor for us to have him with us today. With immense respect, may I now invite Honorable Justice K. Chandru to deliver the Chief Guest address. Sir, please.
Dear friends, before I go to the topic, I must tell you that it's another very important topic that we are going to discuss today. Not only legal education, but also the profession, the practice and the reforms. And it is most important that we discuss this issue now than before. And I am happy to come to Kochi to attend this mainly for two reasons. My inspiration to law, and later as a lawyer, and later as a judge, came from the soul which lived in Kochi. Justice V.R. Krishnayar, who was the sole mentor, interpreter, friend, philosopher and guide. And therefore, I am now back to Kochi to see the same place where he lived and 100 years, and not an ordinary life, a life with full of meaning for people who are in the branch of law. And as a judge, I have always received the friendly note, the wisdom and constant reminder as what we should do as a lawyer or as a judge. In fact, I remember he wrote a letter. He always used to write letters to me, and once in a while he'll call me over the phone. And his hearing was little bad, therefore he used to write letters, and he's a prolific writer. And the last letter I received when I was a judge of the Madras High Court, even today I preserve that letter, and I feel so much affected by the letter. The letter ended by saying, he said, Chandru, is there any hope for these people in this country from the judges of this court? And that question keeps coming to me. And now more than before, I think that we did not have a Krishnayar continue to guide us, monitor us, and oversee our role as judges. And today I'll find there are two things I must tell you about legal education. Not that we are great expert on this. In fact, no judge is an expert. He may be a jack of all trade, but master of nothing. I am a strong votary that judges should be kept away from law schools for two reasons. In US, every judgment of the court is criticized by law schools, law professors and law school. Today in India, we find slowly the role of the academic in criticizing the judiciary is coming down for two reasons. One, they are afraid of the judges. Second, the judges themselves part of the administration of some of the universities. And many of the chief justices have also become chancellors of the national law universities. And that really a factor which slowly curtails what is called the jurist point of view. Today we do not have a jurist. For example, yesterday the collegium recommended a lady, a lawyer, you must have read in the papers, and she's from Coimbatore, she's from South, and she's been elevated. If you see the Constitution provides for elevation of a High Court judge to Supreme Court. And she's not a judge of any court, but she's elevated. And she comes from what category? She comes from an eminent jurist. Because there is nothing mentioned about directly lawyers being promoted. Now, when you say eminent jurists, do we have a class of jurists in this country who continuously monitor the judiciary and then try to tell them where they went wrong? Today, if you find the Supreme Court, you must be reading in the papers, two things they are discussing. One, whether the school children should know about judicial corruption. Heavily they came down against the NCRT, remove that book. In that book, there is only one chapter on judiciary, consisting of 3 pages. 4 lines dealt with corruption. Now the 4 lines corruption, it should not anger you. Then the judges say, no, that book should be withdrawn. You know, 1.81 lakh books have been withdrawn. Very substantial revenue for the government has gone. You could have pasted a small page on that and then give it, but then withdraw. The books have been withdrawn. Now, who wrote the book? Take the subject expert, remove them. We always learn in law college, here the other side. Principles of natural justice, nothing is there. Remove them. How dare they write to the children about judiciary, about corruption in judiciary? It is not as if there is no corruption. That is an admitted fact. In fact, yesterday also in Madras High Court, there is a new film by Surya called Karuppu. I don't know, you might have seen, may not have seen. That movie shows some judicial corruption. So somebody got agitated and said, ban this film. It brings down the judiciary. And the 2 judges very fortunately said that there is a corruption is an admitted fact. And by banning the film, what are the message that we are doing? And therefore we will not entertain this petition. If that is true, why not children should also know about this institution? This is one issue. Now why you should spend so much time? Fortunately, the Chief Justice of India later withdrew the order of the removal of subject expert. All right, that's all right. What I'm saying is, what are your priorities? Are you going to examine and x-ray the school textbooks? How many cases the courts have examined the legal education part of, which is more important for the judiciary, which is the fodder for the judiciary? And now how many hours were spent on this issue? This is one issue which you will have to keep on asking. On the other hand, last week, Supreme Court was hearing a case where law students' attendance should be compulsory or not. Should it prevent people from writing examination or not? You see the priorities. Now, judges are saying, no, we will entertain this or not. Because one High Court said attendance is a must. Now they are examining whether law school should have attendance as a barrier for writing exam. This is something very simple. From the beginning, in my opinion, legal education was never taken very seriously, both by the consumer and also by the administrators. I remember when I got enrolled as a lawyer, we go before the Bar Council and there is a small ceremony, we take a oath, and then they say you are allowed, and you sign the register, you become an advocate. Then the Bar Council chairman thinks that he should give advice to you. The first advice we got from the Bar Council chairman was, gentlemen, now that you become lawyers, now start reading law. This is how the legal education was approached. This is a serious advice he gave. Only when we entered the profession, we realized many of these things were never taught in law colleges. If it is taught, it was always said in a very wrong notion. For a long time, you see the preamble. In the entrance of your college, there is a preamble of the Constitution. In fact, last year, the Kerala government has given the preamble to school students. Now, the preamble very significantly says equality, fraternity, and liberty. These three words. When we were sitting in law college, the teachers were very, when you say enthusiastically telling these three words were the inspiration from the French Revolution. I am not undermining the French Revolution. French Revolution did bring up the subject of democracy, did question the monarchy, I agree. But when you tell the student, when you tell the law student, are you telling the truth? Were they inspiration from the French Revolution? This is one question. This is always, we wrote, whatever they said we wrote, and then we got passed and we became lawyers. For a long time later, when I was listening to one of the brilliant speech of Baba Sahib Ambedkar in 1954, he gave a All India radio talk. You must be having an Android phone, you can even listen to the talk. AIR talk by Dr. Ambedkar. You listen to the talk. He says that there are many people who think that this preamble was drafted after getting inspiration from the French Revolution. They are wrong. I am a disciple of Lord Buddha, and I am a disciple, I am bound to preach his message to the world. And my inspiration came from the Sangha, the Dhamma. These three words were part of a Buddhist tradition. This is a speech made by him, who the author, who is in the drafting committee. Now, how many of us are told in college this fact? It's not as if it's not available. It's there available in books. They're available in text. And therefore, what we learn in college, is it really the real thing, is the issue. In fact, before I joined law college, they were teaching Roman law. You will be very surprised. At that time, the thinking was, Roman law, you must learn to become a lawyer. This is how the understanding. After a long fight, that was removed, and they brought something like a legal theory. Every time it was an ad hoc decision. And the ad hoc decision continues. In fact, Justice Chelameswar was mentioning some of the case, including Shreya Ghoshal case, another brilliant case. Section 66A of the IT Act was struck down for grounds, you may be wondering. The ground taken by the bench was likely to be abused. A parliamentary law was struck down by the Supreme Court on a ground that it will be abused. In fact, he was also honored in an American university, I think, outstanding judicial contribution. Now, this is something which you will have to think, that we will have to think in a different way, not in the traditional way. When the Constitution was enacted, there have been hundreds of hours of discussion. 3 years they discussed this. Hundreds of thought process have gone in. And during 1948, they decided to go to the people. So a draft constitution was sold for about half a rupee. And at that time, it was sold for about 1,15,000 copies were sold. People were interested in what kind of form that we are going to have for this country. And thousands of petitions received by the Secretariat of the Constituent Assembly. Recently, 2 research scholars went to the archives and then drafted and then collated all the views received, and then how these views were either reflected or discussed within the assembly. Though the Constituent Assembly was not a representative body, it was an ad hoc body, not a true representative body, but the wider consultation that they had to the entire people of India, there were thousands of petitions were received. In fact, that book is there available in the market. You can read that book, How India's Constitution was Made. When I was reading, one important representation I saw in that book at page 56. That was a petition sent by a women's group in Kumbakonam, that is Tamil Nadu, to the Constituent Assembly. You will be very surprised. The draft constitution had a provision where they wanted to abolish untouchability. I don't think today anybody will raise their hand saying, don't abolish. At that time, there were people who were seriously objecting for the abolition of untouchability. Now this petition, which is quoted in the book, these women are telling the Constituent Assembly, sir, please don't touch that, don't do that. Why? There are people who are blind, there are people who are deaf, there are people who are dumb. It is because of their past sin. Untouchability is also because of their past sin, therefore don't abolish. Now this is something which I was shocked, because the philosophy behind our constitution, the attempt made by the constitution makers, how much difficulty they faced during that period, never taught in law school. We were simply said for Article 14, 15, 16, 17, that's the end of the matter. Never the pain behind drafting this provision. In fact, you must know one thing, Article 14 to 17 is a string which wanted to achieve social justice in this country. Before this constitution, there was a British rule, there were Mughal rule, there were also Hindu kings all around, and none of these reigns, they never guaranteed equality for the people and also non-discrimination. Article 15 is the jewel of this constitution, which says that the state shall not discriminate on grounds of caste, religion, sex, language, or descent, or any one of them. Now, Article 15, how much time we spend in colleges? Now, that is most important issue. Do we really teach the constitutional spirit to the students? Not just for examination. You may even introduce to school students. They must have the knowledge of the constitution. All that is correct. But how many of us really think, what is the pain went before this? You know, this is a 100th year of Vaikam movement. Vaikam, you all know, it's not a temple entry, walking in the streets adjacent to the temple. Now that temple entry or the walking in the streets did not come on one day by the Travancore Maharaja issuing a decree. It was a people's movement. It was a social movement. And when the movement was picked up, Mahatma Gandhi was forced to come. And Congress never involved in any social movement, but then they were forced to come. And Gandhi was one man who wanted to persuade people. He thought there is still scope for persuading. He told, I will speak to these orthodox people and convince them. You know, these are all part of records today. The Vaikam records you can read. There were 8-hour talk between Gandhi and the orthodox people of Vaikam. And Gandhi got tired of these arguments. Finally, he asked one question, the simple question. He asked them, you show a single Dharma Shastra by which people could be excluded from public access. You know, the answer was very, very funny. The answer was, Babuji, they always address him, Babuji. Babuji, everything need not be based on Shastra. There is something called belief, something called faith. My father, my grandfather, my great-grandfather, all my ancestors believed. Why should I reject that kind of a faith? And therefore Gandhi got so tired, he went off. And the movement picked up, and finally Travancore Maharaja issued a decree, not only walking in the street, you can even enter temple. You must have read this story. Now we are having a centenary on this issue. Yesterday I read in one place, after the decree passed by the Travancore Maharaja, where people can enter any temple, irrespective of caste. The Cochin Maharaja passed an order. He said, anybody coming from the Travancore region, and if they are doing pujas, don't appoint them in any temple in Kochi. I don't know how many of you would have read that letter, that decree, because they felt that since you are doing puja in a temple where everybody is allowed, the temple itself is polluted, and therefore those pujaris cannot do pujas in Kochi. Now this is something which can never be explained. And Malabar was a forerunner for the temple entry movement. You know the whole history of Guruvayur and other things. Why I am saying this was, this painful drafting of the constitution, and where these 4 articles have come together as a string: equality, non-discrimination, non-discrimination in public places, and abolition of untouchability. In this process, recently if you read, there is a judgment of the Supreme Court in Sukanya Shanta's case. In Sukanya Shanta's case, the Supreme Court for the first time declared that the introduction of Article 15 is a social revolution. The leftover caste remnants have been sought to be removed, and the judiciary must also play an activist role in removing the remaining vestiges. In short, the Supreme Court said that after the introduction of this constitution, where the fundamental principle is a social justice, where Manu has been buried, for the first time you could see that the caste system, which has been reigning for over the years, has been sought to be removed by a constitutional declaration. And how many of us have ever taught these things in colleges? This is a fundamental question. This year, 1926, same, this 2026, go back to 100 years back. On December 23rd, 24th and 25th, in a place called Mahad, there was a conference convened by Baba Saheb Ambedkar. The issue was whether they can go to a public temple, public tank. That public tank was maintained by the municipality with the people's revenue. But the Dalits are not allowed because they will pollute. They said the question is, if you are going to maintain a tank, if you are going to maintain a water source, why we can't have water from that? And Dr. Ambedkar said, we could have got water from any well sources also. But the question is, why you are excluding a section of the people? What is the principle behind it? Now this question, on the 3rd day of the conference, he took a book and then lighted that book with a fire. That book was Manusmriti. Next year, this December, we will be celebrating a centenary of burning of Manusmriti. Now, what is that we are taught on Manusmriti? Nothing. India's great culture, great tradition, everything is there. Now, Manusmriti also says what is the justice for any caste, X, Y, Z. Now, one of the lecture that you are going to have in the afternoon is the famous essay prepared by Dr. Ambedkar, Annihilation of Caste. You must read that book, because you get to know many things which we have not been taught in law college. And most of our law we will have to learn outside, not because it's only go by a structured course. Beyond that, if you ask question, they may throw you out also. Many times we got thrown out from law colleges, asking wrong questions. And I will always proudly say, my understanding of Constitution came from the streets and not by law colleges. It was in 1975, when there was an emergency was declared, and the fundamental rights were suspended. 22,000 leaders were kept inside. The question, you are still learning Constitution, still learning liberty, still learning right to speak, still learning right to move throughout the territory. Then they ask, fundamental question, ask the teacher, where are these things available in this country? They say, no, you are talking too much, get out. That's all right. But then our understanding was outside. This is how this Constitution works. I remember, I am only telling you because there is nothing which everybody, when he was saying, our understanding of Constitution is very poor. In 1975, they brought a total censorship of newspapers. You have censorship for films. Whether censor is permissible or not, you also had a case, Kashmir Files number 3 case you had. I'll come to that later. When the press censorship became important, and all the papers used to carry some blank news because censor said it can't be published. Last minute you can't change. So the blank papers came. The entire first page will have lot of white spaces. Then another order issued, because people may ask question why there is no matter printed. Then they said there is nothing should be kept blank, you must fill up column. So newspapers last minute they'll put some flowers to put that column. And this was challenged in the Madras High Court, heard by the Chief Justice Kailasam, who went to Supreme Court, another puny judge. And Mr. Venugopal appeared in this case. Venugopal is one of the very sober lawyer. Recently he has written his biography, you may read that biography. I'm not on that issue. He is very sober, he never get angry. First, when the case began, we were watching what's going to be argued. He told the judges, please look at the Constitution, Article 19. And then judge kept quiet. Then the court master gave the book and they put the flag, 19. But then Chief Justice kept quiet. 3 times Venugopal said, please see Article 19. Then reluctantly the Chief Justice said, we have read it in law college, so need not see it again. And Mr. Venugopal, despite his soberness, he walked out of the court. Since you know everything, there is nothing for me to argue. The case was dismissed. But most important thing was this kind of attitude, this kind of indolence that I know everything. In fact, when the Chief Justice said we read in law college, it was not a truthful statement because he studied in law college before the Constitution. So this could not have been the subject that you would have learned. Secondly, the modesty. Every time a provision of law is shown, I'm a labor lawyer. Even in my sleep I can reload sections. If somebody shows a provision, I'll read again. Every time we look differently. Every time our understanding goes up. There's nothing like that. I've learned everything. What we learned is only a fistful of sand, but there's a whole big world behind. And now, I want to ask the simple question. In the District Judge Gwalior case, you know that case where a district judge was asked, she went to give a bouquet to the High Court judge in Madhya Pradesh. She's a district judge. And then, birthday of the judge, so you want to show some honor, she went there. And the judge, you know, will be shocked. She told the district judge, today you look very beautiful. Why don't you put a dance for me? She's a district judge of Gwalior, and the High Court judge tell her to dance. And then she just put the bouquet and went off. She was transferred to a far-off place, and she challenged in the Supreme Court. And the argument went on for quite some time. During that argument, her lawyer, Indra Jaising, she has also written her biography, which is very important to learn because I will not go into that, I'll tell you. The Madhya Pradesh High Court was represented by a senior lawyer, and the matter was heard by the Chief Justice Kehar. Whenever Madhya Pradesh lawyer got up, it was always the habit of Indra Jaising to interfere. And you must have seen that. She will get up and say, it is all wrong. So what we do, you please take your seat. When your turn comes, you can argue. Chief Justice said, and she took her seat. But the Madhya Pradesh senior lawyer told, my lord, don't stop her. Her interruptions are delightful. Now the word delightful, and Indra Jaising got up and started shouting, saying that, am I putting some performance here? And you are using the word delightful. You better withdraw that remark. And Justice Kehar, in his judgment, actually you should read the judgment. Additional Judge Gwalior versus Madhya Pradesh High Court. In para 17, Kehar starts by saying, every day is a learning process for us. Chief Justice of India, one of the biggest court in the world, and third in the hierarchy, writes very modestly, every day is a learning process. What does it mean? That we'll have to learn, keep learning. when Indira Jaising objected to the word, first we thought there is nothing wrong in the word. But then every word will have to be deconstructed and see whether there is a misogyny behind that meaning. And we realized Indira Jaising was right in objecting. And first time we learnt a lesson. And this was the word. And after several years, Chief Justice Chandrachud issued a booklet, which are all the words we should remove from the writing judgments. Suppose you say he, we'll have to say person. There is nothing like he. There is nothing like a man world. And there is a small booklet which is available in the website. I thought it's very important because 2019 judgment got some reflection in 2024 in form of a direction. All the district judges are told, when you write judgment, you should carefully avoid all the male words and it should be gender free. Now this booklet you can see. Suddenly another bench comes in now saying, these are all Harvard specialities, we will not have this book. We will appoint another committee to decide, write a new book. This is where the question comes. When the judiciary, which we think is a continuous organization, which we think has a larger vision, starts a petty fighting. This is a Harvard view. Now they talk about Chandrachud as a Harvard view and that book is discarded. What is the message you are sending? Is that wrong? Is that book is wrong? No, this Harvard understanding should go. This is a very important issue that we feel. When we talk about certain issues, this system is a British system. This system is a colonial system. This interpretation all should be thrown out. We have our own better interpretation. There are some judges who keep on saying this. Therefore, the legal education today stands on a very question mark. What we learn is proper or not is one thing, or we are going through some guilt process where we are only being told whatever the colonial education, we are continuing to do this. So discard this. There is one judge in Madras High Court, Mr. G.R. Swaminathan, you must have read him. He said, in fact he has quoted extensively, he said all this British interpretation should stop. We have interpretation in our Ramayana, we have interpretation in our Mahabharata. So we should have a Indianized jurisprudence. What is this Indianized jurisprudence? That you should understand. If you think law is a universal, you think that certain principles that cannot be compromised, then we should also welcome any knowledge from any place. Why do you say Indianized jurisprudence? What is that you are meaning that? And then what he says is, I'll tell you how it happens. There is a judge from Kerala High Court who came from Madhya Pradesh, and now he is the Chief Justice of Madras High Court. And now he is the one who decided Kerala files case at the midnight hearing. When he came to Chennai, he addressed one law college students. Now every judge gives their dose of advice, like we are also doing. Now what he said was, today the law students are all after corporate advocacy. National law schools are only orienting people from corporate advocacy. How to wean them away? This is important. How to wean them away? Now, he says our students should be taught our old tradition. They should be taught Manusmriti. I don't understand that how from corporate management you bring to abolish or teaching Manusmriti. What do they learn? Do you think what the Supreme Court said in Sukanya Shanta, that Manusmriti is being buried? The vestiges of casteism should also go and judges should play an activist role. Now another judge says, teach them Manusmriti. That is why when Ambedkar burnt a copy of Manusmriti, he also made a very historic speech. You can read that. He says that this is a concept which we can never agree because a justice system cannot have a substantial section of the people kept away, kept below animal status. How you can call this as a smriti or a justice system? In fact, in his book, he also explained one important event. Every epic in our country has got some side stories. He talks about the story of person who tried to learn Vedas. and then if you learn outside your caste, then what is the punishment? Manu says, if a person should not learn something or should not hear something, pour molten lead on their ears. That's a punishment. And this man was brought to the office of the king Ayodhya, Rama. What is the punishment that is to be given him? He learned Veda while he is a scheduled caste, who is not supposed to learn, and his head was chopped. Now people started questioning that if Rama is such a great avatar, he's got a great attribute, why he did not show leniency? Why there was no compassion? This question is asked. Rama is considered to be a very important figure. For us, maybe avatar. If you go to UP, the Islamic people refer to him as a Maryada Purusha. He may not be avatar, but a man, respectable man, who stands for virtue. Now this question was, why did he kill Sambhuga, who learned Vedas illegally? He says, don't blame Rama. He's a Kshatriya king. The justice system is based on Manu. And he has imposed the punishment that has been given Manusmriti. And therefore, as a Kshatriya king, he enforced law. If I write a judgment based on a law passed by the parliament, you can't blame me. You'll have to blame the parliament. Similarly, he says, don't blame Rama, blame Manusmriti. Because it is he who has stratified the society into different castes. And there are Savarnas and Avarnas. 4 castes are Savarnas, those who don't fall outside. Now this question keep coming. I am asking a fundamental question. Do we learn any of these things in college, in our legal system? Forget caste, poverty. In fact, in Chennai, I am associated with the School of Journalism. When we are framing a curriculum, we had a paper reporting poverty. Don't report VIPs, sports champions, or some cinema, Hollywood cinema. Report the common people. And there is a paper, a compulsory paper on reporting poverty. In fact, I am also part of some of the board of studies in law. I have been advocating we must have a poverty jurisprudence. Today you learn law college, many things you learn, but you don't learn what is a law or what is a system that applicable to majority of the people in this country. 80% of the people don't have any great resources. There are several development schemes. There are several laws applicable to them, but we never teach them in law college. Only when you go outside, you start learning, whether it's a rental law or a tenancy law or any other matter, or any development scheme like Narega. Now it is called, change the name also. That is VG, which is Viksit Bharat, some Ramji Act. Now they give all these new names. Now I am saying, today what we learn in law college or the syllabus, is it rooted or it is suited to the larger population of this country? When a man comes from a village and says, as a tenant, he has been thrown out by the landlord, then where do you go? You go buy a book, start reading Land Tenancy Act, or if it is a city tenant, start reading TT Tenants Protection Act. Why you are not teaching this? Therefore, we have a legal system where we prepare people only for the rich, only for the people who got a greater sense. And therefore, when you talk about the legal syllabus or the new legal education, we should now start opening. Is it relevant to the larger population of this country? We have 147 crore people. Do you have a system where it is relevant? Do you learn anything about them? Or you learn only when you become a lawyer? Why you are not training the lawyers on this issue? This is something which you keep asking. And second question that I want to tell you, that it's just not the legal syllabus. We keep on discussing. Very foundation of our profession. Forget corporate lawyering. Very foundation of profession. In fact, recently, the Chief Justice of India got into trouble by saying cockroach and parasites. Cockroach and parasite do what? They are asking RTI questions. No other work except RTI question. Then the question was, why do you call them cockroach? Why do you call them parasite? And there is a whole lot of, there was a response to this. And there is a cockroach, Janata Party is now started. Started meaning in inter. Now does it mean 30 to 45% are all cockroach and parasite? What is the Supreme Court doing? Issuing notice, Bar Council. Please do the completion, verification process. Second time extension, third time extension. Now the Bar Council chairman says, who is now recontesting, he now says 35 to 40%. What were they doing? Why you are allowing fake lawyers to practice? Why you are not able to find and throw them out? Now Chief Justice says, I will entrust to CBI. What CBI will do, that's a different issue. I am only saying, we are in a profession where there are several, not several, substantial people who do not have any credentials to practice. Now you allow this system to continue. And we call them as learned brothers. Some of them you will also get promoted as judge. In fact, one judge in Madras, his degree was not a bona fide degree, but he was made as a district judge. Only at the time of retirement, they found he does not have a degree. Then what they could do? He is already 58 years old. So they allowed him to retire. He is getting pension. He is writing articles, everything is there. Now I am only saying, is our profession or the responsibility given to the superintending bodies like the Bar Council is really effectively functioning? That's a question that you will have to ask. Because we thought there will be an autonomy for this profession. Judiciary should not control because it should be an independent profession. Before 1926, there was no Bar Council. In 1926, Bar Council Act came where the power was with the judiciary to remove a person or enroll a person. In 1961, Parliament enacted the Advocates Act where they also said Bar Council will be independent body. Now if it is independent body, why is that there is a proliferation of so many fake lawyers? This question will come in. Third is, what is the motive that you build? If you see all the old chronicles of lawyers, leading lawyers or leading judges, two important attributes. First, he had a lucrative practice. That means he minted money. In fact, Justice CHELAMESWAR talked about some Supreme Court lawyers making money. Abhishek Manu Singhvi, who is also a Rajya Sabha member, he has to declare his asset in the Rajya Sabha. His declaration is published. He is now owning 2,680 crore rupees of assets. And his annual income is 330 crores every year that he gets from this profession. And now this is a profession when the attribute is, are you a lucrative practice? Second practice is a chip of the old block. That means he come from a great descent. So this profession is meant for two people who make money and then who come from a family of lawyers. Now if this is the attribute, in fact in 2010, our High Court published an annual book. Our Chief Justice, 2007, our Chief Justice told me, you write a page on lawyers. Before I write the page on lawyers, I don't want these two attributes, lucrative practice and chip of the whole block. I didn't want to. I asked our Chief Justice, what is your criteria of a good lawyer? He told me, you tell me first. I said, in my opinion, in my experience, he must be a fearless lawyer. He must fight for a good cause without expecting any returns. In fact, we used to have a pouch in our gown. Now the tailors don't put the pouch. In those days, the clients will put the coin in the backside. The lawyer will not see how much money is being put, but still you will have to argue. Now the pouch is removed like our appendix. Our appendix is no role, therefore the pouch is also removed, even as a symbolic gesture. Now, I said, if we can argue fearlessly, unmindful of the consequences, and he can take the judges to task, and then he does not mind what is the money, he is a great lawyer. So I wrote he said, you carry on. You will see our annual book in 2007 talks about lawyers who were different, who were not in any chronicles before. Their names were never been there, and they are all mentioned for the first time. In fact, Kannabiran name we have mentioned in that book. We have mentioned Vanamamalai, we mentioned V.G. Rao, we mentioned several lawyers who sacrificed their life for a better cause, and that is most important. And then what our profession teach, I remember that the beginning of the 20th century, we have a bar association. The bar association was started in 1902. It is only meant for the barristers who go to England, get a barrister thing and come back here, and they become. The barristers started an association for themselves. Nobody else will be allowed. At that time there was no law degree. There were Indian lawyers practicing in smaller courts. Only barristers can appear in the High Court. So this association meant for barristers. An American Indian has written a history of this association. Very interesting book. He has tabulated the first resolution passed by this association in 1905. Two resolutions. First resolution is none of us should have any undercutting of our fees. That is, you should not say you are charging 1,000, you come to me 500. Not. You should fix the fee and get it. No question of undercutting. Some market arrangement. Only traders will have. Don't reduce the price. All of us should sell the same thing. So you go to a market, you may not get bargain anywhere else. The second resolution was, you should not engage a tout. Tout means a broker. There was also a legislation against tout. Because you should not get somebody feeding you and then pay commission. These are the two resolutions. When the Bar Council was framed later, they did not remove this resolution. They are part of the Bar Council. Even if you today, in 1961, when we formed an independent Bar Council, the Bar Council rules, there are two rules you will be surprised to have. One of the Rule 21 says that you should not quote any fee in derogation of your status. That is, you shall not quote a fee in derogation of your status, meaning if you are a big lawyer, you should quote that fee only. You should not quote some cheap fees. There is another rule which says you should not foment litigation. Now these two rules I am asking, I was also a member of the Bar Council. I had given several representations, these rules should be removed. There is a poor man. You go and tell him you have a right. That's fomenting litigation. Then what is the meaning of our legal aid? We are telling legal awareness. Our legal aid service authority has got two phases. One is to appear for the poor. Second is to tell the people, this is your right. Go and make them aware of their right. Now that is prohibited in our Bar Council. Therefore, what we do, our Bar Council is a replica of the old tradition of this profession. And we try to import the formal tradition where making money is the only goal. And in making money, the families of lawyers will have a greater hold. And today, for the first time, we feel that kind of hold is slowly gathering away. Even then, still there is a hold, but then not of the 20th century beginning. And therefore, we'll have to look ourselves. This Bar Council, elected by ourselves, and now we have a rule which is going against the interests of the people. If you see the Constitution, in fact, when Rahul Gandhi, wherever he goes, he takes this book. This pocket book carries. I am very happy because it has become very popular. This is published by the Eastern Book Company in Lucknow. Last month, that Eastern Book Company published a small announcement. This book has been sold 1.55 lakhs copies. Not lawyers are not buying, judges are not buying. Ordinary people want to know because Rahul Gandhi is carrying this. He goes and tells everybody, DNA of the Indian people. In fact, in the Bihar election I saw, he was showing some agriculture women in Bihar, in East Bihar. He was showing this book and say, DNA. All the women were clapping. They don't know what is Constitution. They don't know what is written here. But then their leader is carrying the book. The book has become popular. The book has become more and more popular because common people would like to know what is written in here. And therefore, the interests of the common people is more. Many people used to ask, what do the poor people know about Constitution? If poor people want to know, I will say you, any person who is above 18 years can vote. Irrespective of caste, religion or any discrimination, there is no discrimination. Except our SIR discrimination. Very disastrous judgment which you have seen now. During the SIR queries, several people are omitted, and district judge tribunals have been constituted. Now there is an appellate tribunal with retired High Court judges. 34 lakh applications are pending, and Supreme Court says that citizenship is a prerequisite for a voter. In fact, CHELAMESWAR was explaining about how the difference between statutory right and a constitutional right. What is lacking today is a constitutional right. We have a constitutional democracy, but there is no constitutional right to have the democracy exercised by our right. That's not there. Now Supreme Court, apart from upholding SIR, which is there in Kerala also, we've seen the country, they have given an extra version by saying all the people who do not able to justify their citizenship, this matter should be given to the Home Ministry, and then Home Ministry will start the expulsion process. It is just not answering questions in a case. It is answering questions for the government what they should do. Unsolicited advice. Unsolicited advice, how do you question? Does anybody question this? No. Today law colleges don't discuss the contemporary issues. The contemporary issues which really affect all of us, and we don't discuss. Either the teachers don't encourage you, or we have got better business to do, therefore nothing to discuss. This is an important issue, that when the court fails, when the court tries to go on a different track, we can take a stand saying that this is not correct, this cannot be allowed. In 1975, he remembers, we were in law college, we went against the emergency, against the internal emergency. We were on a strike. Then the teachers are asking, what is your concern with this? I said, this is our future. This constitution has to be upheld. This constitution should be defended. Like we celebrate 26 November 1949 as a law day. Then government said, we will celebrate it as a Constitution Day. Now everything is a Hindi word, Samvidhan Day. Now suddenly the Modi government has announced, Samvidhan Hatya Divas. Constitutional Murder Day we are celebrating. Now if there is no Constitutional Murder Day, 26 June 1975 is a Samvidhan Hatya Divas. That day we are celebrating. Now the question is, who is murdering this Constitution? Is he thinking about 50 years back what has happened, or what is going to happen today? Today it's most important, that what's happening today is most important. Are you upholding this Constitution? And therefore there are different arguments of no coming. I won't go into details. There is a constitutional morality. In fact, he questioned that very idea of morality in one of the lectures. But what is important today is that the principle or the faith under which this constitution has been framed, under which we have been knit together, under which our neighboring countries have failed, and we are able to still hold together, this principle has to be established. That is in the minds of the law student. And therefore there is a greater scope for a constitutional principle, not just a few questions and then forget it and go to the High Court and one judge saying, we have read everything in law college. That may not be a very correct thing. And therefore the third question that comes in is our future. Is this profession is going to give us anything at all? And why do we take that kind of a importance or a trouble to become a lawyer? So many lawyers are making so much money. Abhishek Manu Singhvi, 330 crores. There are lawyers who charge per day 50 lakhs. More than the Hollywood actors or Bollywood actors for that matter. That is not a correct practice. The correct practice is we are learning a trade, we are learning a profession, and we take a oath at the time of becoming a, I shall uphold the Constitution. If you want to uphold the Constitution, you will have to work. This Constitution refers to only 3 places, lawyers. It does not talk about legal education, talk about lawyers. You must be knowing Article 22 talks about a pre-trial detainee is entitled for a lawyer of his own choice. Lawyer of the word lawyer is mentioned there, only one place. Lawyer of the choice means, is it a pyrrhic choice? Somebody is taken away and he doesn't engage a lawyer. He can't engage a lawyer. It may be a suicidal for the trial to go on. If you don't engage a lawyer, if there are no lawyer, like you see in the Delhi High Court, against Kejriwal. He refused to participate. Now that the judge said, I will appoint amicus curiae. That's a different issue, that argument we won't go. What is important today is a lawyer is an integral part of the right to guarantee of liberty. Now if we are integral part, are we discharging our right or our obligation that as a lawyer? A man comes to you, he doesn't have money to pay. Are you willing to take his case? Are you willing to defend him? Or you say, no, this case is a dangerous case, we won't do it. And therefore, the constitutional right becomes illusory right. The other two places where there are lawyers are referred is Attorney General and Advocate General. There are two references are there. But there is no other reference. But there is also a fundamental duty which says that we shall excel in all spheres of life. We shall excel in all spheres of life, includes this sphere of law. And there is a fundamental duty for us to defend the common people of this country. As the days may grow, there may be more and more problems for the common people. And then, as a lawyer, like everybody says there are not enough judges, population, same thing applies to lawyers also. There are not enough lawyers. While some lawyers have got all the brief, other majority of lawyers don't have any brief. In fact, we made a study in 1975. We made a study. We found 80% of the cases are won by only 5% of lawyers. The rest of the 20% are discharged by 95% of the lawyers. And therefore, there is an unequal distribution. There is a monopoly is there. How to break this monopoly? There is a requirement of a lawyer. In many cases, they go underrepresented. Then the answer is 39A, legal aid to poor. In fact, the author of the legal aid to poor is Justice Krishna, the greatest standing monument for the common people. In 1973, when he was a law commission member, along with in your internet, process going to deter, you will have to substitute. Based on the report, some all equal in the and Government of India took this concept, that is a duty, started a new unit called legal aid. 25 students are there, only all the senior lawyers. All of you should take 5 legal aid briefs in our country. This charity never works. That I must help this person. We only say we have a legal. Beyond that, they have no access. Now, this is another issue. Instead of calling an aggressive system, this is one issue, and this legal education. If at all we conceive some, that vision should be the Swaminathan says, the collector who came to India made tons of, and there is not much of a legal education, legal firm, parties, and then those seniors, what kind of barrister he is. Most of the time she'll say, but structure was evolved. A structure of legal education.
Your valuable thoughts and perspectives in India. Our next Council of India, with great respect of the Bar Council of India
and legal practice have entered the law college. Access to legal materials was meant spending long hours. Today, a young court proceedings virtually. Yet, the question remains the same for the challenges. As rightly pointed out by your principal, legal teaching statutes and precedents. Practice is vastly different. Artificial intelligence is beginning to influence
the scheme of things of legal learning or learning law in law colleges, because I learned law in 85-90 batch. I was also a 5-year law student, where the democratic spaces in public educational institutions were better utilized by bringing in whatever that is being happening around, where every single class people will be talking about so many, the implications of the contemporary situations, whether that is happening today. Let us just introspect. And so many associated aspects also we need to introspect, because learning law is a different cup of tea. It is applied legal education that we want. With these few words, I offer, or rather I congratulate the union, the present union, and I should mention one specific aspect, that this is an institution which has crossed 150-year landmark. It gives me, even while I was serving here, it was so exciting for me, even though I was not able to join that momentous occasion by remaining within the scheme of things of this institution. But again, whether we have done justice to that big momentous occasion, have we attained distinct, whether we were able to get distinct advantages of an institution which has celebrated 150 years of existence, whether after the momentous occasion, what were the takeaways for this institution, what distinct difference was there as far as this institution is concerned. All these things have to be discussed. I learned that there are so many students from outside, faculty members from outside, but I think there is a public educational institution should take up the cause of reimagining, restructuring, etc., because they should be the leaders, because they have got a very prominent role where the society expects a lot from public educational institutions. With these few words, I congratulate once again the union, and also am extremely thankful for associating me with your every single venture. I'm committed to help you. I'm committed to mentor you as long as I am in good spirits and good health. Thank you.
Thank you, sir. A constant pillar of support to the student community and the institution alike, the PTA continues to play an important role in fostering academic growth and collective progress within the Government Law College, Ernakulam. With great respect, may I invite Mr. Dinesh Shenoy to deliver the felicitation address. Sir, the dais is yours.
നമസ്കാരം. കോളേജ് യൂണിയൻ 2025-26 ലോ ജേർണൽ ക്ലബ്ബ് ഭഗത് സിംഗ് സ്റ്റഡി സർക്കിൾ ചേർന്ന് സംഘടിപ്പിച്ച നാഷണൽ കോൺഫറൻസിൻ്റെ 2ാം ഘട്ടമാണ് ഇവിടെ തുടക്കം കുറിച്ചിരിക്കുന്നത്. ഇതിൻ്റെ അധ്യക്ഷ സ്ഥാനം വഹിച്ചത് പ്രിൻസിപ്പൽ ബിന്ദുമോൾ മാഡം, ഉദ്ഘാടനത്തിനായി നമുക്ക് എത്തിയ ആരാധ്യനായ ജസ്റ്റിസ് ജസ്റ്റി ചലമേശ്വരൻ സാർ, വിശിഷ്ടാതിഥിയായി എത്തിയ ജസ്റ്റിസ് കെ ചന്ദ്രു സാർ, മുഖ്യപ്രഭാഷണം നടത്തിയ മനോജ് സാർ, ഡോക്ടർ ഗിരിശങ്കർ, ഡോക്ടർ പ്രേംസി, സദസ്സിലിരിക്കുന്ന മുൻ വൈസ് ചാൻസലർ ശ്രീ കെ.എൻ. കുറുപ്പ് സാർ, നമസ്കാരം. പങ്കുവയ്ക്കുന്നതിലൂടെയും ചർച്ച ചെയ്യുന്നതിലൂടെയും വളരുന്നതാണ് അറിവ്. ആധുനിക വിദ്യാഭ്യാസ രീതികൾ പങ്കുവയ്ക്കാനും ചർച്ച ചെയ്യാനുമുള്ള മഹത്തരമായ ഈ വേദി ഒരുങ്ങിയ ഗവൺമെൻറ് ലോ കോളേജിലെ PTA അംഗം എന്ന നിലയിൽ ഇവിടെ വന്നെത്തിയ എല്ലാ നിയമവിദ്യാർത്ഥികൾക്കും ആശംസകൾ നേരുന്നു. നല്ലൊരു മാറ്റത്തിനും നല്ലൊരു തുടക്കവുമായി ഈ സെമിനാർ മാറട്ടെ എന്ന് ആശംസിച്ചുകൊണ്ട് നിർത്തുന്നു. നന്ദി, നമസ്കാരം.
Thank you, sir, for your words of encouragement and support. As a token of our gratitude and appreciation, we shall now proceed to the memento presentation ceremony. May I respectfully invite Dr. Bindumol VZ, Principal, Government Law College, Ernakulam, to present mementos to our distinguished guests. Ma'am. I request Honorable Justice Justice Chelameswar, former Judge of Supreme Court of India, to receive the memento. Thank you, sir. Next, I request Honorable Justice K.Chandru, former Judge of Madras High Court, to receive the token of respect. Thank you, sir. Next, I invite Advocate Manoj Kumar N, Vice Chairman of Executive Committee of Bar Council of India, to receive the memento. Thank you, sir. Thank you, ma'am. The mementos stand as a small token of our immense respect and gratitude for their invaluable presence and contribution. As we approach the conclusion of this inaugural session, it is now time for vote of thanks. Bold in spirit, graceful in character, and known for her warm and amicable presence, she has been an active and inspiring part of the student community and the college union. With great pleasure, may I now invite Ms. Nandana Shine, General Secretary of the College Union, to propose the vote of thanks. Ma'am, please.
Respected dignitaries on the dais and off the dais, esteemed faculty members, distinguished guests, members of the media, and my fellow student friends. Good afternoon all. As we come to the close of this inaugural session, it is my pleasant duty to express our sincere gratitude to all those who have contributed to the success of this National Conference second edition. First and foremost, we offer our deepest gratitude to Honorable Justice Jst. CHELAMESWAR, former Judge of the Supreme Court of India, for inaugurating the conference. Sir, your presence among us today has been a matter of immense pride and inspiration. Your words have set the tone of the academic deliberations that will follow and have reminded us the values and responsibilities that accompany the legal profession. Thank you, sir, for sharing your valuable insights with us. We extend our sincere thanks to Honorable Justice K.CHANDRU, former Judge of the Madras High Court, for being our chief guest. Sir, your reflections on law as an instrument of social transformation have left a lasting impression on all of us. Your life and work continue to inspire generations of law students to view the law not merely as a profession but as a means of advancing justice and equality. Thank you, sir. We are grateful to Advocate Manoj Kumar N, Vice Chairman of the Executive Committee of Bar Council of India, for delivering the keynote address. So your guidance, encouragement, and support throughout this journey have meant a great deal to us. Your association with this conference extends far beyond today's address, and we remain deeply thankful for your constant support and confidence in our all efforts. I also express my sincere gratitude to our Principal in Charge, Bindumol Miss, for presiding over today's function and for the support and encouragement extended at every stage of organizing this conference. Your guidance and confidence in student initiatives have been invaluable throughout this journey. Thank you, ma'am. A special word of gratitude to Dr. Girishankar sir. So your support and encouragement have accompanied us throughout the planning and execution of this conference. Your faith in us and has motivated us to work harder and strive for excellence. Thank you so much, sir. We also extended our sincere thanks to Mr. Dinav Shenoy sir. Whenever we approach him with a concern, a request, or a challenge, or anything, he always stood by us and offered his support. So your encouragement and willingness to help have been invaluable throughout this journey. Thank you, sir. This conference is particularly meaningful because it is the result of a truly student-led effort. Behind today's successful inaugural session lies months of planning, coordinations, discussions, and hard work. Much of this work was carried out during the vacation period when many students were engaged in internships, academic commitments, and personal responsibilities. Despite these challenges, a dedicated team continued to work tirelessly to ensure that every detail was taken care of. Their commitment and sense of responsibility deserve our highest appreciation. I would also like to place on record my sincere gratitude to every volunteers, union members, and all the club conveners who work behind the scene. While much of their work may not be visible from the stage, their dedications, patience, and hard work have been the foundation upon which this conference stands. Their efforts have played a crucial role in making today's events possible. Our thanks also go to all faculty members, teaching and non-teaching staff whose cooperation and support were instrumental throughout the process. Finally, we extend our gratitude to the media representatives, participants, delegates and well-wishers and every individual who joined us today. Your presence and participation have greatly contributed to the success of this session. As we conclude the inaugural session, we extend our best wishes to all participants for an engaging, insightful and rewarding conference. May the deliberations and discussions over the coming days broaden your perspectives, deepen your understanding of the law and inspire all of you in your academic and professional journeys. Thank you.
Thank you, Nandana Shine. With this, we come to the culmination of the inaugural session of the second edition of National Conference on Shaping the Future of Legal Education, Innovation, Practice and Reforms. Once again, thank you all for your gracious presence and participation. This is Monica Paulos signing off from the inaugural session. Thank you. A small information, currently it is lunch break. Our participants are provided with food. After the lunch break, everyone are requested to reach the venue at sharp 2:30 p.m. Thank you.